Good morning. My name is Gary Bourne, and it's a great pleasure to have the privilege, the honor to make this keynote address for the International Arbitration Week in Armenia. I'd like to apologize, first of all, apologize for not being able to be present in person. I think in a COVID or post-COVID era, virtual performances or attendances are more than satisfactory, but I would have much preferred to have been there in Armenia with all of you. Again, apologies. I'd also, though, like to thank the Ministry of Justice in Armenia and the Center for Legislation Development, in particular Tigran Daduntz and David Garabayan, for their extraordinary assistance and competence in organizing this seminar and also inviting me here. Of course, as well, I'd like to thank the Asian Development Bank and Christina Pack for their support to the center and to the ministry in organizing this weekend. Also, the important question of law reform in the area of international arbitration in Armenia and indeed the entire region. It's more important today, perhaps than ever, that we respect the rule of law, that we respect the rule of law in international commercial matters, in all other aspects of international affairs, international life. It's especially important to respect the rule of law, to enforce the rule of law in international commercial matters, because unless parties are able to enforce their contracts, unless parties are able to enforce the decisions that resolve disputes arising out of their contracts, then they won't enter into those contracts in the first place and will be deprived of the enormous economic, social, and other benefits that come from commercial transactions, particularly cross-border investment, cross-border trade, which is of such an enormous benefit to all of us. An adequate means of international dispute resolution, giving effect to the rule of law, is therefore essential. Businesses around the world, from every part of the globe, from every political system, have for decades now preferred international commercial arbitration, also investment arbitration, as a means of resolving cross-border disputes, of ensuring that when they conclude contracts, those contracts will be effectively enforced and that the results of their dispute resolution processes also will be respected. Parties have preferred international commercial arbitration, giving effect to the rule of law, for what I call the 6 E's. And let me first briefly recite those 6 E's and then say a few words more about each one of them. Those 6 E's are comparing international arbitration on the one hand, and then other forms of dispute resolution, competing forms of dispute resolution on the other hand. First of all, expertise, that's the first E. Then expedition and efficiency, even-handedness, enforceability, and in this post-COVID era, as this remote address suggests, electronic ease of communication. And let me explain a little bit more about what each one of those E's stands for and why, taken together collectively, those 6 E's make international arbitration the preferred mechanism of dispute resolution in international matters, both for businesses and for governments all around the world, including in Armenia and the region of the Caucasus and Central Europe. First, international arbitration's defining characteristic is the freedom of the parties to select the tribunal, the decision makers that will resolve their disputes. There is no standing court or tribunal of existing judges who can hear every international dispute. In contrast to national courts, arbitral tribunals, the arbitrators, need to be selected by the parties in each case as that case arises. The parties have the freedom, the autonomy to select those who will resolve their disputes, just as they have the autonomy, the freedom to conclude international arbitration agreements in the first instance. That autonomy, that freedom of contract is an essential aspect of cross-border trade today. What that means, though, critically, is that the decision makers in an international arbitration are chosen for their expertise by the parties. The parties exercise their autonomy after a dispute arises to choose the arbitral tribunal that is most competent, most expert in resolving their dispute. To take a few examples, if the parties have a construction dispute involving a road or a dam, they choose arbitrators who are experienced, expert in international construction matters, perhaps with specific expertise in road or dam construction. They also choose arbitrators inevitably as part of a three-person tribunal who bring a host of capabilities, a host of competences to bear in their particular dispute. Perhaps one arbitrator may have particular technical expertise, another arbitrator may have particular expertise in the law applicable to the party's dispute. And by doing this after a dispute has arisen, the parties who know more about their dispute than anyone else in the world are able to ensure that the arbitral tribunal, a tribunal typically of 3 arbitrators, has more expertise than any other tribunal that might be assembled to resolve that dispute. Compare that means of selecting an expert tribunal to the situation in national courts, where national court judges, with their enormous abilities, nonetheless are faced with the difficulty of resolving all manner of disputes that may be brought before them: criminal disputes and civil disputes, administrative disputes and tax disputes, employment disputes, sale of goods transactions, intellectual property disputes. Every sort of dispute that might be brought before a national court judge is one that she or he must be called upon to resolve. And necessarily that means that those judges lack the expertise that a tribunal selected specifically for a particular cross-border dispute will have by virtue of the parties' exercise of their autonomy. And so one of the first and most important reasons that commercial parties prefer international arbitration, that it is the preferred mechanism for international dispute resolution, is precisely the expertise and thus the reliability and ultimately fairness that the international arbitration process provides as compared to the alternatives. Moving to the second of the 6 E's, expedition, which is related in a sense to the first E, expertise. International arbitration is typically more expeditious, more quick, faster than the alternatives for several reasons. One of the reasons is exactly that the parties have chosen an expert tribunal who therefore need not be educated in the basic subject matter, whether it's construction law or insurance law or M&A transactions. The arbitral tribunal starts out with all the requisite expertise. Related to that, of course, is the fact that the tribunal is much less likely, therefore, to go down false paths, to make decisions which require reconsideration or which take the parties in directions which really have no relevance to the ultimate resolution of their dispute. Naturally, that saves time and money if an expert tribunal is running the procedure of the arbitration. Moreover, international arbitration rules, the institutional arbitration rules that have been adopted over the last several decades, have emphasized the need for expedition in the resolution of disputes. Many institutional rules, whether the International Chamber of Commerce, the ICC rules, or the Singapore International Arbitration Center rules, have adopted fast-track arbitration procedures which provide for the resolution of disputes, the making of a final award in no more than 6 months in smaller value disputes, typically disputes involving only a couple $1 million or less. These fast track proceedings where a final award finally resolving the parties' dispute is rendered in only a matter of months compare very favorably to the circumstances that exist in many national courts. Related to that, of course, is the fact that in arbitration, there are not multiple layers of appellate review, with one appellate court reversing the first instance decision, then a second appellate court restating the first instance decision, and perhaps more of exactly that same sort of toing and froing, often without adding any reliability or accuracy to the ultimate dispute resolution process. In contrast, international arbitration has no appellate mechanism. It has a very important annulment mechanism, which provides a check on the arbitral tribunal's procedural fairness and on the jurisdictional excesses of tribunals should they do so. But apart from that, there is no review of the substantive merits of the arbitrator's decision, something which causes commercial parties no concern given the expertise that the arbitral tribunal has in the first instance. And so for all of those reasons, arbitration is, as compared to the alternatives, national court proceedings or administrative proceedings, typically significantly more expeditious. And that brings us to the third of the 6 E's, efficiency, which is closely related to expedition. Time is money, as they say. And the longer a dispute resolution process goes on and the more forums in which it occurs, the more money the parties will be required to expend on that process, diverting their investments from more productive uses, whether it's building factories or paying workers or something else. Because the arbitration process is more expeditious, because it doesn't have multiple layers of review, and because arbitral awards, as we will see, are relatively enforceable all around the world, that process is necessarily more efficient than the alternatives. Arbitral institutions have also, in the last several decades, made concerted efforts to ensure the efficiency of the arbitral process, both by constraining the fees that arbitrators can charge and ensuring that the process is conducted efficiently, and also in adopting rules that permit arbitral tribunals to impose sanctions on parties that engage in delaying or other types of guerrilla tactics that make the arbitral process in extreme cases less efficient than it should be. The fourth of the 6 E's is even-handedness. The arbitral process, in part because of the party's role in choosing the arbitral tribunal, and in part because of the experience of arbitral institutions, is more even-handed, more neutral, more objective than the alternatives. National court litigation, almost always in cross-border matters, involves litigation on one or sometimes both parties' home turfs. If you have a dispute between, say, a French and an Armenian party, the French party necessarily will seek recourse in French courts, where the Armenian party will understandably feel disadvantaged. Perhaps for the same reason, the Armenian party may well commence proceedings in Armenian courts, where the French party, conversely, will feel just as disadvantaged as the Armenian party does in Paris. In contrast, international arbitration involves proceedings in a single forum, a single international forum in which either the parties jointly select the presiding arbitrator or alternatively a neutral international arbitral institution not based in or beholden to either of the parties selects the presiding arbitrator. As a consequence, both in practice and according to most institutional arbitration rules, the presiding arbitrator, she will be of a different nationality of either of the disputing or any of the disputing parties, providing a significant degree of national neutrality that doesn't exist in the litigation context. Equally, the parties' joint role in selecting the presiding arbitrator, or alternatively, the arbitral institution's role as a neutral, fair decision maker in selecting the presiding arbitrator, guarantees that he or she will have neutrality, significant neutrality as compared to the alternatives in national courts. And again, this reason, the even-handedness of the arbitral process, is one of the chief grounds that international commercial parties have preferred international arbitration to the alternatives. That brings me to the fifth of the E's, which is enforceability. The New York Convention, with some 170 contracting states from every part of the globe, is a global constitution for international commercial arbitration. The New York Convention has amongst its contracting parties every significant economy in the world. There are a few holdouts, North Korea and the like, but apart from that, every significant economy in the world is a party to the New York Convention. And what the convention does is to guarantee two things. First, that international arbitration agreements will be recognized and enforced subject to only the most narrow of exceptions. And second, that international arbitral awards likewise will be recognized and enforced in all 170 or so contracting states, subject again only to narrow exceptions designed to ensure procedural fairness, to guarantee that public policy isn't violated, and to prevent jurisdictional excesses. In contrast, there is no global convention for either forum selection agreements or national court judgments. There are some regional mechanisms that attempt to replicate the New York Convention, but they have significant defects, and as I say, they only do so on a regional basis. As a consequence, when parties conclude international arbitration agreements, they do so with the confidence that those agreements will be recognized and enforced all around the world. And in practice, national courts have done an excellent job in upholding the provisions of Article 2 of the New York Convention and enforcing international commercial arbitration agreements. Likewise, once parties have obtained through the arbitral process an arbitral award resolving their dispute, they do so with the confidence that that award will almost always be recognized and enforced again all around the world in all 170 contracting states or so. In contrast, there is no parallel, as I mentioned, for national court judgments on the one hand or forum selection agreements on the other hand. And of course, the enforceability of arbitral awards lends its support to the efficiency and expedition of the arbitral process. One can be confident both that arbitration agreements will be enforced swiftly and efficiently, and arbitral awards likewise will be enforced efficiently, assuming parties don't voluntarily comply, which they very frequently do. And that brings us finally, at the conclusion of my remarks, this keynote at the opening of Arbitration Week here in Armenia, to the electronic advantages of international commercial arbitration. These were brought to us by COVID-19, which, although bringing us many other unhappy consequences, brought us the possibility of remote or virtual hearings. Today, most procedural directions hearings, most hearings involving no witness testimony, most hearings involving only a single day or so of testimony will be conducted virtually, remotely. Technology has been used to realize very significant cost savings when large numbers of lawyers, witnesses, experts, and clients have to be transported halfway around the world to an expensive arbitration venue. That no longer need happen. Instead, and in contrast to many national courts today, post-COVID, international arbitration hearings can be conducted efficiently through virtual means, just as I am appearing virtually before you this morning. International arbitration has also used technology and other ways, remote access to documents, which allow witnesses to be cross-examined efficiently, albeit virtually. And when in-person hearings are required, as they were in the old days, they can still be conducted and very frequently are conducted for larger, more complex hearings. But the possibility of virtual hearings, in contrast to how many national court proceedings today are conducted, allows once more significant savings in time and money. And so for those 6 reasons, the 6 E's, international commercial arbitration provides the preferred means of cross-border dispute resolution. I know in the coming days, you will explore in detail various aspects of international commercial arbitration. I hope this keynote, this setting of the stage, is useful and that you can keep it in mind as you discuss the finer points of international arbitration in the coming days. It is essential to realize the rule of law in commercial matters, in investment matters, in all other walks of international affairs, that disputes can be resolved reliably, fairly, efficiently. And that is what international arbitration promises. And I promised the organizers that I would only speak for 15 or 20 minutes, and I think I've kept that promise as well. Again, I'm very sorry I couldn't be with you this week, and I look forward to hearing the results of your deliberations. Thank you.